Why Supreme Court had to clarify the governor's powers? Can a repassed bill be reserved for the president? What is the Supreme Court's holdings and what are the reasons behind it?
The Supreme Court today ruled that the courts cannot impose timelines on the president or governors and that the idea of the deemed assent is completely alien to the Constitution.
A bill which has been repassed by the assembly can still be reserved for president, and that's a clarification we have got on governor's power by the Supreme Court holding this time, which is a major development in center-state relations. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh and today we will be understanding that what Supreme Court has clarified and why this clarification was required, what it changes in the center-state relations, how did this come through the presidential reference and everything around it. So let us begin with understanding the whole issue and the timeline around it. It all started with when we saw that multiple states were complaining that their governors were either delaying or withholding the bills with themselves. That means blocking the assent to the bill. And majorly it was seen in Tamil Nadu, Punjab, Kerala, where the governor even went ahead and sent the repassed bills to the president. Now this led to a lot of confusion that if the assembly has repassed the bill, then can governor send it to the president or reserve it for the president, or he must give the assent, or he has other options. There was a lot of clarity which was required, and amidst this came the April 8 ruling. It is important to talk about this ruling as well because this ruling is what brought the presidential reference. So when we are talking about April 8 ruling, it was related to the case Tamil Nadu government versus the governor R.N. Ravi. In this particular case, Supreme Court clearly came up, the district bench came up with a clarification that governors withholding assent is absolutely illegal, and even the Supreme Court went ahead giving proper timelines to the governors as well as president for giving the assent. And then came the presidential reference, which is provided in our constitution through Article 143, where the president can seek advice. This is the advisory jurisdiction of the Supreme Court from the Supreme Court, specially related to the details required around constitution or understanding, deeper understanding of constitution. And under this, our President Draupadi Murmu sent in 14 questions to the Supreme Court related to clarification on governor and president powers as well. Now, when we are talking about this particular holding that we are going to discuss, Supreme Court has clarified that what they are saying here is an advisory opinion. It is not binding, but it is highly persuasive and it should be followed. Now we will be understanding that what Supreme Court has gone ahead and said. But in the very same matter, this April 8 ruling as well as presidential reference is very important if you want to understand this in detail. I have already covered it almost a month back in detail. You can go and watch that video as well. Now talking about the recent clarification that has come. So the first thing we need to understand, which are the two key articles here. Two key articles are here, Article 200 and also Article 201. So when we talk about Article 200, it simply says that whenever a bill comes to the governor, he has simply three choices. The first option he can give assent to the bill. The second option is that he can return the bill for reconsideration by the assembly. So this is the second option he has, but in this second option he has certain limitations where he cannot return the money bill. Can you tell me in the comment section why cannot he return the money bill? And the third option he has, that he can decide to reserve the bill for the president. Now for this, the Supreme Court has clarified. The proviso of Article 200 says that if a bill is returned and repassed, the governor cannot withhold assent. That means governor has to give the assent. But the word that has been used here is returned. Governor can still decide to assent it, give the assent, or reserve it for the president. The article and the proviso does not mention reserve. It only talks about withhold. So in this way, the Supreme Court has gone ahead and clarified that even if the bill is repassed by the assembly, there are two options, not three options, two options left with the governor, that either he can just go ahead and give the assent or he can reserve the bill for the president. When we move to the other article, that is Article 201. In this scenario, when a governor reserves a bill that is for the president, right? Now, what can president do? President can assent the bill, withhold the bill, or return the bill as well. Now, 6-month time limit applies to the returned bills. For example, if the president has said that okay, the assembly needs to reconsider it, the time limit here is for the president. This time limit does not exist for the governor as per Article 200, and this has been clarified again. So, as an implication, the constitution clearly treats that governor's role and president's role are different, and this has been done intentionally. The power that has been placed and the discretion that has been placed, it is different for governor as well as the president. Now, when we have understood two articles and what Supreme Court has pointed out here, now let us go ahead and start it from scratch and understand that what was the main question that was put in front of the Supreme Court. The main question that was put in front of the Supreme Court was, can the governor reserve a bill even after the assembly has repassed it? Now, this question is very important. If yes, the governor can reserve the bill, then the center has the final say even after the state assembly which has been elected who has passed it. That means center has some kind of control over the state matters. If no, then we get to see that governor must sign the bill after the state assembly has passed it. And when we give, as it has been said, yes, this power is available, we understand that it totally changes and affects the center state power balance that exists. Now, that was the main question. Now, the answer to this question was yes, the governor can reserve even after the bill has been repassed by the state assembly. And Supreme Court has further clarified why. They have said the phrase shall not withhold assent applies to only withholding, not reservation. And the reservation is a separate constitutional power. So, repassage does not cancel the governor's power which is present to have the president's opinion. Even if the assembly has repassed it, governor still has the power to get the opinion from the president, and that is why even after the passage of the bill, the governor still has two options. First, either directly give the assent to the bill or reserve it for the president. Now, when we have understood what Supreme Court has gone ahead and clarified, let us understand why Supreme Court had to clarify this. The first thing here you need to understand is the textual meaning. The Constitution clearly prohibits withholding, not reserving. So, if the framers wanted to remove reservation, they would have clearly mentioned it in the Constitution itself. Second, it has a direct impact on the federal structure, center-state power relations as well. So, in this scenario, the reservation that is given to the governor that he can seek the president's opinion is to make sure the sanctity between union-state relations, interstate issues, constitutional right, judiciary-related matters. All of such matters can easily require opinion, and that should be available in a scenario where the repassage of bill has also occurred. Now, when we are talking about the main concern is to prevent the loopholes. If the reservation was disallowed after passage, then there would have been state assemblies, that means they can bypass the union by simply repassing the bill. And this would weaken the federal oversight where we have placed a stronger center in the federal structure of our country. Another important dimension that needs to be highlighted here is the fact that you have to understand the April 8 ruling came by the district bench. Now, this particular advisory opinion, as per for the presidential reference, has come through a constitutional bench. Can you tell me in the comment section, what do we mean by constitutional bench and how many Supreme Court judges are included in the constitutional bench? Right? Now, this advisory opinion is out. Now, the main question here is, this verdict is out. Now, the main question is, what are the implications of it? There will be implications on the state government. That means the repassage will not give them a free pass and a guaranteed immediate assent. Politically sensitive bills can still go to the president. They will still have the opinion of the president, and states must anticipate federal concerns and try to balance them if there are any, which has been assured by this particular verdict. Apart from that, for governors, it will also bring in that they cannot delay bills indefinitely. Supreme Court has also further clarified two very important things. That when we are talking about putting timelines on governors giving assent to the bill, it is not right. So, this is in reference to the April 8 ruling that this cannot be done. But at the same time, they have warned governors that if they delay the assent to bills indefinitely, SC can intervene, Supreme can intervene. This inaction is not right. So, governors have to either give assent or reserve them, and if they have reserved, they have to justify the reservation on constitutional as well as federal grounds. And overall, for the federalism structure of our country, this strengthens centre's oversight rule, ensures national coherence in sensitive legislation, and it also might be the reason for increasing political tension, especially in opposition-ruled state. Because if the parties are different at centre and state, there is a reservation by the governor, who is the agent of the centre, might create problems. Now, on this note, I will be leaving you with a prelims practice question here. You can give me your answers in the comment section. Now, I will be revealing the answer of yesterday's question, which was related to US, Pakistan and Saudi Arabia's nexus video. The correct answer here is A. That was all for today. Thank you so much.